Welcome, everybody, to another episode of Tax Sale Insiders. I'm your host, Brian Seidensticker. I'm CEO of Tax Sale Resources. And with me today, I've got Matt Abey. Matt is with Nelson Mullins, and Nelson Mullins is one of the few, I'll say, attorney firms that specialize in tax sales, or at least have a specialty in tax sales, which is unique and highly advantageous in this industry. I guess, Matt, thanks for joining us.
Yeah, glad to be here. Good to see you again.
Likewise. I guess glad or not glad. I guess we'll kind of dive into some of that. I know you've been appointed, by NTLA to kind of investigate this Supreme Court case, and maybe I should just turn it over to you. But as far as my knowledge goes, this court case was started in Minnesota, really specific to a single property that was foreclosed on due to delinquent taxes, has gone through several different levels of court and is now sitting at the Supreme Court level, right? Ultimately trying to decide something that is pretty impactful for the industry. But why don't we start with that? Can you give us a quick background of how we got to where we're at and what this is all about?
Yeah, this is the case name is Tyler versus Hennepin County. It is based out of Minnesota. Mrs. Tyler sued not just for herself, but on behalf of a class of property owners that are affected by Minnesota's tax in-rim tax foreclosure process. Minnesota uses a forfeiture process where roughly 5 years after delinquency occurs, the absolute title to the property forfeits to the state. And the local county will then sell the property after bringing it up to code and making sure the property is habitable. They can sell it. What a lot of people don't know about the process in Minnesota is that there are all kinds of protections in place to try and avoid some sort of forfeiture. As you know from talking with a bunch of tax collectors, the last thing they want to do is sell the property. What they really want to do is find a way to help people in stay in their properties by paying the taxes, redeeming the property, doing whatever they can to avoid a tax sale or a forfeiture. But ultimately, there's got to be some finality in the process, and Minnesota law sets that final step as forfeiture, so that the county can get it back onto the tax base and the tax rolls as a property that's used either commercially or residentially, and is a beneficial part of the community. So what happened in this case is Miss Tyler owed a couple $1,000s in back due property taxes. The county then added, as was required under statute, certain penalties and interest and costs associated with the tax sale process, so that the total delinquency was roughly $15,000. The county then, at the end of that 5-year process, when there was the forfeiture that occurred, then fixed up the property and sold it to a third party for about $40,000, creating a surplus or an overbid or an excess proceeds of roughly $20,000, $25,000, which the Ms. Tyler, on behalf of herself and others, is claiming to have a property interest in. She claims that this equity that she has is a protected property interest under Minnesota law, and is something protected under the federal Constitution from being taken without the ability to get it back. So essentially what she wants is the surplus proceeds, regardless of how much it costs the county or the state to sell the property at tax sale, enforce the taxes, fix up the property to make sure it is back up to code. She wants the surplus that she claims is her equity in the property. And of course, notwithstanding all the notices and abilities that she had to redeem the property or sell it and protect that interest in it. She's represented by an entity called Pacific Legal Foundation. Pacific Legal Foundation is a group that has researched what they call equity theft around the country They say there are about 12 to 13 states in the country that don't give taxpayers the right to claim the equity in their house if it's sold for or forfeited as a part of an in-rem tax foreclosure process. They brought another lawsuit out of Nebraska that was brought. It was a class action about the same style as this one out of Minnesota. That went up to, they requested the Supreme Court hear that case around the same time, and the court didn't act on that case and instead took Miss Tyler's case. She's raising two claims. That first, the sale and forfeiture of her property without returning the surplus and her equity to her is a taking of a condemnation or akin to eminent domain of her property, and it's a taking without just compensation. So she claims that the compensation that she's entitled to is the equity, and that's a protected property right under both Minnesota law and the United States Constitution. Because as we know, the government usually cannot go out and just build a roadway across your where your house is without paying you for that land. She's trying to expand the concept of what a property interest is under the takings clause in order to protect her surplus or equity in the property. So that's the first argument that she's raising. She's also claiming that the tax sale was an excessive fine, and she goes back to the fact that she only owed about a couple thousand in actual property taxes that were delinquent, and that the property ultimately sold for about $40,000. And she claims that's an excessive fine under the U.S. Constitution, and it's not permitted. Of course, in making that argument, she ignores the numerous attempts that the county had to go back and try and get her to satisfy the delinquent taxes or redeem the property in order to avoid this forfeiture, like I said, as a last result in a 5-year process. So those are the arguments she raised. The district court, which is the trial court in the federal system, dismissed her case, said that there wasn't a claim as a matter of law. The appellate court, the Eighth Circuit, agreed with that and ruled that there wasn't a takings claim because the equity or surplus proceeds is not a recognized property right under Minnesota law, and so it could not be a taking. And then ruled that because this dealt with a remedial tax collection scheme, it was not a fine under the U.S. Constitution. She petitioned the U.S. Supreme Court in a process called certiorari, and which is just a long way of saying that the U.S. Supreme Court doesn't have to hear every single case that is presented to it. It has discretion about whether or not to tell the court below that it wants to hear the case. And it does so very rarely. It certainly does. It's certainly very rare in tax sale cases. There are not a ton of tax sale cases before the U.S. Supreme Court, and it decided to take this case. It's going to be heard. Briefing's going on now. Ms. Tyler has filed her brief, and soon Hennepin County and its treasurer will file. I believe it's like the end of the month. Will file its brief in response. And then the parties will argue the case before the U.S. Supreme Court on April 25th. And we would expect the decision sometime this summer, usually the end of June, beginning of July, roughly, for a case argued around this time. The parties are asking the court, they're attacking this from very different directions. Obviously, the county wants to uphold its tax collection mechanism. It believes in the due process protections that are in place for people like Ms. Tyler, believes that it's giving them proper notice, believes that it's giving them a lot of different options to avoid losing their interest in the property. And it's through essentially the inaction of the taxpayer that causes the sale or forfeiture of the property. And so they're arguing that it's just not, they're essentially arguing with the courts, and the Supreme Court should agree with the courts below that there's no property right in equity or surplus proceeds that's protected under the takings clause of the Constitution, and that there's no excessive fine here because it's a remedial tax that's being levied against Ms. Tyler and others. So you mentioned earlier that we're writing a brief for the NTLA, and we're writing what's called an amicus brief, or a friend of the court brief. And the amicus brief is intended to share the thoughts and the experience that the National Tax Lien Association and other groups have in this arena. As you know from the work that you do and the podcast as well, there are a million different types of tax sales across the country. Not only do you have different tax sale schemes and styles and methods that vary from state to state, but you even got some states that have multiple different methods, or you've got some counties that do it different than other counties, and municipalities, like the larger municipalities, might do it differently from some rural county. So it's really the different schemes are out there in such a way that this case could have implications across a number of different types of tax sales. And the Supreme Court should be very careful not to. They could paint a very broad rule in this case, paint with a very broad brush, and have implications across the entire nation and the entire industry. And so we're hoping to, as a part of our amicus brief, just outline the different types of tax collection methods that are out there, and urge the court to be very careful with the way that it looks at this issue, because it could have very big implications for a lot of different states, not just those ones that the Pacific Legal Foundation and Ms. Tyler have highlighted in their brief.
Yeah, so I guess a couple things I want to highlight that you mentioned, Matt, is at first blush, right, when you say I only own $2,000, right, but you say now I owed at least 15, right? I think it's important to remember it didn't jump from 2 to 15 overnight, right? It was 2 plus some fees plus interest, and I think what you pointed out, which is rare, I guess, and I've interviewed attorneys all across the country and have learned a lot about the process, but a 5-year delinquency before forfeiture is actually quite long compared to many states. I mean, there's states that it may go longer, right, depending on what the lien holder decides to do, but typically it's much shorter before that forfeiture takes place. So I think that's key to point out. And I think the other thing that I think you're going to get into, but I definitely want to dive into a little further, Matt, is it, this starts in Minnesota, but it, like you said, it has a much larger potential impact, right, depending on what the court says. So can you dive into that a little more of like what exactly the implications and impact could be?
Absolutely. Let me touch first on the point that you made about the amount going from a couple thousand to 15. You're right; it's not overnight. Minnesota's statutory scheme adds that on over time. And if you think about it, the county has a budget shortfall that it's filling with the tax sale. Not just Hennepin County, but counties across the country have tax sales in order to fill somebody that is not paying their property taxes. And they have to get that revenue from elsewhere. And so the interest and penalties and costs that are added on, those usually would be at roughly a market rate for what a county would have to go out to in order to make up that shortfall. So it's not something that occurs overnight. The taxpayer gets notice throughout the process, both in this county and in others across the country. And there are ways that they have rights of first refusal or rights to redeem all the way through the process to avoid that amount getting too high too fast and not being something they can come back from. So that was the first point. The second point, as far as how it might impact some of the other states, you don't know. It's always tough to read the tea leaves with the U.S. Supreme Court. You've got 9 justices that come from different backgrounds and different experiences as far as what their practice areas were when they were practicing attorneys. I doubt that any of them really did a lot of tax sale work. I doubt that they were folks representing investors and whatnot. And so they're going to be looking at this from a different angle than you or I might, and might not think about how one minor change, when we're talking about one state out of 50, and coming down with some sort of rule that says, oh yes, this is a property right that is subject to the taking analysis, that could have implications for tax sales across the country and could really send legislatures in every state scrambling to try and tweak their process a little bit to bring it up to the standards that the Supreme Court might impose. What I think is interesting is that the United States government, through the Solicitor General, filed a brief earlier this week that essentially, it's an amicus brief as well, a friend of the court brief, that essentially doesn't take a side. It says we're in support of neither party, we're not opposing either party, but let me just share with you our thoughts from the federal government. And the brief was very careful in the way that it talked about how tax sales and tax collection would be considered a taking under the takings clause or a condemnation in eminent domain. Because you got to remember, the federal government also engages in tax collection efforts. And so it would be, the government recognizes that this case could have implications also for the federal scheme, the federal tax collection scheme. So it's important, I think, that the court draw a narrow decision here and resolve the issues in front of the court, but mindful that it can really impact a number of different industries. And then when you start talking about real property and title to real property, as you know from our chats in the past, real property issues and title issues, those can stick around for a very long time and have just kind of a ripple effect to other owners of the property down the chain. So it's something that I know the Supreme Court will look at very carefully, and we're hoping that the NTLA and these other parties that are filing amicus briefs will be able to shed some light on how this case can impact more than just the parties before the court.
Yeah, it's not just the single property, and it's not just Minnesota, right? Depending on what they decide to do, could put every tax sale system nationwide into at least a question, right? Do we fulfill whatever they say it needs to fulfill? And then also puts every single tax lien or tax deed that's sitting out there right now in question of was this legitimate? Is there a chance of having it overturned? I mean, there's a like you said, who knows, and depends on what they say, but there's very wide-reaching, and it's not just isolated to that property, that county, that state, right?
That's right, and a good point that you make there about with Ms. Tyler bringing this as a class action. That let's say that the court reverses and says that there's a problem with Minnesota's tax collection scheme. Well, what happens to every single tax sale that has occurred in Minnesota in the same year, not the tax sale, but the tax forfeiture that occurred in Minnesota in the same year that Ms. Tyler's tax sale occurred? We don't know what would the impact there would be, but you're calling into question the title that may have been sold to somebody else, and somebody's house might be sitting on that property now. And so it's a lot more than just a very. It's not just a tax sale issue that's kind of a amorphous, nebulous idea that's out there. It has real world implications for a lot of different people.
Yeah, for sure. Well, what if it's okay with you, Matt? Can we pivot a little bit to NTLA is filing this amicus brief, and I guess what is the current message that NTLA is wanting to portray through that amicus brief?
Yeah, so we're planning on filing, and I think our deadline is the beginning of April. We're still working through some of the arguments, but generally speaking, we intend to file an educational brief rather than advocate strongly for one party over another or one specific type of tax sale over another. We intend to educate and hope to educate the court on the different styles of tax sale around the country, and the different trade-offs, the policy considerations that go into adopting and enforcing tax collection efforts nationwide. So I think it's important, and we hope to convey that all the different legislatures across the country have really studied tax collection and how it impacts their citizens, and they've made conscious policy decisions to do one style over another, or to limit the right of redemption to residential properties and not commercial properties. They've also made policy decisions in trying to create resources and programs that would allow taxpayers who are delinquent because they've fallen on some hard times or lost a job or had health issues to be able to apply to avoid being in the tax sale for that year, or some sort of tax forfeiture. Those are all policy considerations that are really studied by the legislature and implemented because they know their citizens best and they know what works best. And so we're hoping to explain to the court that it's really tough for the court, one sitting in D.C. that doesn't have daily interactions with the people that are impacted most by its decision, to then say that one style of tax sale or one method of tax forfeiture over another is better. So in the hopes that the court will see that that there's a wide range of styles, and they can all be proper under the Constitution, without just looking at this one very narrow subset of tax sale.
Got it. So is it safe to say it's kind of, I guess, educating the court on right now it's decided at the state level and maybe it should stay decided at the state level? Is that fair to say?
Yeah, to some extent. So there are certainly federalism principles at play here, that the concept that the states are closest to the people, and the states are the ones that their state legislators, they go home at the end of the week and see the people that are in their districts and are impacted by, have daily interactions with the tax assessor or the auditor or the treasurer and tax collector. And they know they've got a better feel for how tax collection impacts their citizens. It's harder for Congress on the federal level to try and legislate for all those different issues across all those different jurisdictions. And instead, it's better to allow the states to make those decisions, certainly within the bounds of the Constitution, because the Constitution protects certain rights and provides some guideposts and guardrails. But the states are taking those into account when they include these notice requirements, include these protections that are available if taxpayers will go and seek out those protections, and also include rights of first refusal and rights to redeem that extend all the way up until that absolute last remedy of the tax sale or the tax forfeiture. So these are policy considerations that have been weighed, they've been studied, they've been changed, tweaked constantly. From following legislation around the country, legislators are writing bills and drafting them to make changes right now as we speak. And so it's best to kind of let that process play out and allow those that are really studying the issues with tax collection and have the most experience and expertise with it to make the decisions on how to do those policy trade-offs.
Excellent. Well, Matt, I know there'll be follow-up, what's the current status? And then eventually I definitely want to get back on with you to talk, what was the decision? What are the impacts of that decision? You said probably, midsummer, June timeframe. But as of today, I extremely appreciate your input, Matt. You always have, wise words. And I think NTLA chose the best person to kind of put that amicus brief together. And I guess we'll see how this plays out.
Well, I appreciate that. We've got a good team here at Nelson Mullins that deals with these issues and can. I'm working with partners from about 4 different offices across the country on this. Just based on their backgrounds and the wide variety of experiences they've had with tax sales. So we're looking forward to putting a good amicus brief out there, and would love to come back and discuss how oral argument went, or how the opinion comes down, and what your listeners need to really be thinking about as far as the states that they're investing in, and how those states' procedures might change after this opinion.
Sounds great. Well, thanks everybody for listening. Thanks, Matt, for joining. Good luck. We'll talk soon.
Thanks.